Welcome to week 5 of American Government. And this week we're going to cover two chapters. The first topic that we're going to look at is the court system, focusing on the federal judicial system. Remember that our founding fathers intended to have three co-equal branches of the government. This week we'll continue our study of those three branches. We've looked at the executive and the legislative branches already. This week we'll be looking at the judicial branch, which has the key function of interpreting the law. We'll take a look at what that means and how our system carries that out and how it is structured. When you look at the Constitution, Article 3, it actually covers the judicial branch, and it only mentions one court, and that's the United States Supreme Court. However, the Constitution states that Congress can set up whatever lower courts it thinks are necessary beneath the Supreme Court in our judicial system. Congress first used that power given to it to create lower courts in the Judiciary Act of 1789, which is a law passed way back then. And ever since then, we have had a system of courts in several layers, and we will look at how those layers fit together a little bit later on. Before we get into that, though, let's examine the Supreme Court in a little bit more detail. Our Supreme Court consists of 9 justices, and they're just judges, but when they're on the Supreme Court, we call them justices. I'm really not sure why, to be honest with you. There is one Chief Justice who's supposed to kind of be in charge, and then 8 associate justices who serve with the Chief Justice. They all have equal votes when they decide cases, by the way. I'll say that right now. The Chief Justice's vote just counts as one vote, and so do the other 8. So keep that in mind as we go forward. Each justice gets on the court after they are appointed by the President of the United States to serve. Once the President nominates someone for a vacancy on the court, that nomination isn't automatic. It has to be confirmed or approved by a vote of the Senate, which we saw that earlier. The Senate has the power to confirm or not appointments that the President makes to high up government jobs, and this is certainly a very high-level job. Once that individual is approved to serve on the court by the Senate, he or she is sworn in and then will serve on the court for life. And that's kind of unusual in our system. A justice never has to be reappointed or reelected. And that's true of all federal judges, not just the justices on the Supreme Court, but the judges in the lower federal courts as well. They'll never face a vote of the people. They'll never have to be reappointed or reelected. And there's no age limit. And so the justices can serve as long as they want to, basically. So the only ways that we get rid of a justice from the Supreme Court, the only ways that they can really leave are, first, they die. Second, they resign or retire on their own accord. Or third, they are impeached, which means that they probably committed some kind of serious crime, and so they can be removed from office by Congress. And there's actually a procedure for that in the Constitution for removing even the president and members of the federal government that are high ranking. So those are the 3 ways that we get a justice off of the Supreme Court. By this time, you might be wondering what our founding fathers were thinking designing this system, because they were all about democracy and the voice of the people and all of that kind of thing. So what in the world are we doing with this undemocratic method of choosing judges where the president appoints them, the Senate approves them, confirms them, and then they're there forever? Why do we do that? Well, there was a very good reason for it, and Alexander Hamilton, one of our founding fathers, explained in the Federalist Papers what they were thinking and when they came up with this system. As he explained it, he wanted the justices to be insulated from the passions of the day. And what that means is, because they don't have to stand for re-election, they don't have to go, make friends and hand out favors and whatever that politicians normally do to get elected. They don't even have to be reappointed. They don't have to get on the good side of the president or the Congress or anybody. Once they are on the court, they can do whatever they want, and no one can really do anything to remove them. So because of that, they don't feel the sway of popular opinion. They don't have to worry about whether people like them, whether they'll get reelected or not, whether they have the right friends in high places, none of that stuff. And so they're insulated from all of that. So they can just concentrate on what's right and wrong and making the right decision on the cases that come before the court. And as Alexander Hamilton explained it, they're designed to be the conscience of the government. So the president has to respect the will of the people. The Congress has to respect the will of the people. And sometimes the will of the people might be misguided a little bit. And so here we have these justices on the court who are supposed to be the voice of reason, that even if people get all upset about something and they're emotional and not thinking logically. We have these dispassionate 9 justices sitting up there on the court who can look at the cases that come before them and make logical decisions, apply the Constitution fairly. And so they're free to make all the right decisions all the time, even when that is unpopular, because they never have to worry about winning a popularity contest once they are appointed to the court. And so that's very important. They are really designed to be kind of the grown-ups in the room sometimes, even if everyone else is getting all wound up about something. They're supposed to be able to sit there and not worry about being popular or being liked and just make the right decision. And so it was important to give them that power by making a lifetime appointment. So that kind of goes against our democratic sensibilities a little bit, but you can understand why they did it that way. It certainly makes sense because of the role that they're in. Both of the other branches of government end up having a say in who gets to serve on the court. And we saw that the president gets to nominate the justices that he wants, and then the Senate gets to confirm those justices. That's part of our checks and balances system. The founding fathers wanted to make sure that all 3 branches of government kind of were able to keep an eye on each other so that no one branch got too much power. And so this is how the other 2 branches kind of keep a watch on the judicial branch. If there is a vacancy in the job of Chief Justice, the president has a choice. He can either nominate someone brand new who's never served on the court before, or he can promote one of the associate justices to the top job of Chief Justice. And so he'll still have to nominate them. The Senate will still have to approve that either way, even if they've already been confirmed to the court once before. As an associate justice, if they're going to be appointed to the Chief Justice job, that'll have to be approved again by the Senate. But that is how that works. The process begins of nominating a new justice in the Senate's Judiciary Committee. So the president will nominate somebody, and the Senate Judiciary Committee is a group of senators who handle the issues dealing with the court system. And so they will start taking a look at this individual who's been nominated to see if they're a good fit, and they will begin to hold hearings where they question the nominee about his or her qualifications and viewpoints, and just try to figure out if this person is a good fit for the Supreme Court. This is a very important job. Once we confirm them, we're stuck with them for life. And so we need to do a pretty good job of making sure that they're going to do an excellent job when they get there. After the committee has held the hearings, questioned maybe other witnesses and also the nominee, they'll then vote and either recommend the person to the whole Senate or reject the nomination. Usually they will approve the nomination, but there have been some contentious nominees in the past, and we'll talk a little bit more about that later. But assuming that they recommend the person to the whole Senate, then it'll go out of the committee to the whole Senate, and then that the whole Senate as a whole there will get to vote to approve or reject the nominee. And only a simple majority of senators is required to confirm the nominee to the court. And so if they get 50% plus 1 of the senators who showed up to vote, they will get to serve on the court. And so that means that they are confirmed. At that point, they will be sworn in and begin serving their lifetime appointment on the Supreme Court. Because presidents get to nominate a justice of the Supreme Court for the rest of that appointee's lifetime, nominating someone to the court is one of the most lasting legacies a president can have. A president gets to serve 4 years or maybe 8 if they win re-election, and that's it. But when they nominate someone to the Supreme Court, that person can be on the court for decades. And so that can just leave a really lasting legacy. A good example of that is William Rehnquist, who was first appointed to the Supreme Court back in the 1970s by President Richard Nixon. And Rehnquist served on the court for a number of years until in the 1980s, President Reagan appointed him to be the Chief Justice of the Supreme Court. And in that role, he guided the court through some very important decisions, really had some landmark rulings during his time. And he served on the court until he finally passed away in 2005. And so he was on the court for a little over 30 years. And so President Nixon, of course, left office under a cloud of scandal back in the mid-70s. And so here we had, his legacy living on through Chief Justice Rehnquist clear up until 2005. And so that really gives an opportunity for a president to leave a mark on the country well after that president has actually left office. And so the president may only be around for 8 years, but the nominees that he places on the Supreme Court will be there a lot longer than that in all likelihood. So because of that, a lot of thought goes into the persons the presidents choose to nominate to this office, because they want someone who basically agrees with them philosophically, ideologically, and also will do a really good job on the court and guide the country the direction that they think it needs to go. So presidents spend a lot of time worrying about this when an opening turns up on the Supreme Court, because they want to get that right. Again, because these nominees, once they're placed on the court, do have such a profound effect on the direction of the country, that's caused the nomination of a new justice to turn into a highly charged political battle sometimes. It wasn't always that way, though. Historically, what would happen is the nominee would go up to the Senate and get questioned about their beliefs and their about the law, their how good a legal scholar they were, that kind of thing. But they wouldn't be asked about political issues necessarily, that kind of thing. Their political ideology or philosophy. Mainly, they were concerned about what their legal philosophy was and what kind of legal scholar they were. Did they have enough experience? Were they a deep thinker? Were they smart? That was the kind of thing that we really worried about the most. Well, that changed dramatically in the 1980s when President Reagan nominated Robert Bork to be on the Supreme Court. And Mr. Bork was very conservative, and the Senate at that time was dominated by Democrats who were much more liberal than Mr. Bork, at least. And so they really didn't like him at all. And they managed to defeat the nomination of Judge Bork, not necessarily because he was unqualified so much, but mainly on ideological grounds. They just didn't like what he believed. And so they made a really hard time for him in his nomination hearings, and he didn't make it. He was not confirmed to serve on the court. So anyway, his rejection kind of changed things quite a bit. Unfortunately, I would say unfortunately, that set a new trend, and nominees to the court are now grilled about their political views about hot button topics like abortion. Do they believe in a woman's right to choose, or that sort of thing. And so it wasn't always that way, but now it's become more about that. And nominees are usually coached pretty well, not to step in it too much when they are asked these kinds of questions. They tend to dodge and say they'd keep an open mind and, that kind of thing if the issue came before the court. But it becomes a much more political event than it used to be, because I think every side sees how important it is who we put on the court, and that really does shape the direction of the country. And so both sides, Republicans and Democrats, get really wound up sometimes about nominees to the Supreme Court. Let's go back in time now and take a look at the history of the Supreme Court and kind of how its role changed over time. Now, the Supreme Court began life in 1789 when the Constitution was adopted, but it was in a little bit of limbo at that time. The Constitution, Article 3, set up the Supreme Court, gave Congress the power to create other courts as well, but no one at that time was really sure what the limits of the court's power were or what it would be able to do. And so that was really unsettled at that time. Theoretically, anyway, it was intended to be equal to the other three branches, but no one was really sure if it had enough power to undo anything that Congress or the president had done. It might rule that those acts were unconstitutional, but it didn't really have the power to do anything about it if something like that happened. And so those were some really unsettled questions. And it took quite a few years and some very important court cases to kind of figure out what the boundaries of the court's power actually were. And we're going to look at one of those very important cases, and that's in the case that came up in the year 1800, and it was Marbury versus Madison. If you ever took any kind of government course in high school even, you probably heard that name before. And we're going to look at that case a little bit, and the facts are kind of important, but a little bit involved, so bear with me as we go through that. So 1800, Marbury versus Madison. Mr. Marbury, who was the plaintiff in this case, was appointed by President John Adams, the second president of the United States, to be the Justice of the Peace in Washington, D.C. So he was basically just going to be a public official. Probably wouldn't have that heavy of a schedule, I would guess. But he was going to have this pretty nice government job, being the Justice of the Peace in Washington. Well, President Adams had just lost his bid for re-election to a second term to Thomas Jefferson, and the two didn't get along. That's an understatement. They really hated each other's guts, pretty much. And so his last day in office, Adams appointed a bunch of folks he liked to government jobs. And he was kind of being a little bit snarky there because the idea was that Jefferson would come into office and find a bunch of Adams's people in all these government jobs. And so that would kind of tick off Jefferson, and Adams kind of liked that idea. And so Marbury here is one of these guys that got appointed to one of these jobs by Adams. Well, Marbury wouldn't officially have the job until the papers that were appointing him to the position were delivered to him by the Secretary of State. And so the Secretary of State of the United States had these papers and was supposed to hand them over to Marbury, and that would be, his official start of his job. And so until that happened, he really wouldn't be appointed to that office. Well, these papers didn't get delivered before Adams left office, and Thomas Jefferson came into power as the President of the United States. His new Secretary of State was James Madison. Madison didn't like Marbury. He was one of Adams' people. He didn't want Marbury to get the job, and so he refused to hand over the papers. And so we kind of had a standoff there. Marbury had been promised this job. The papers were there in Madison's office, and Madison just refused to hand them over to Marbury, so Marbury wouldn't get that job. So Marbury, kind of stuck in the middle here, in this power politics play, finally sued James Madison to force him to deliver the papers to him. And so we had the case Marbury versus Madison. The case made it clear up to the Supreme Court, and both sides argued about whether Marbury deserved the papers or not. So when they were arguing this case before the court, that's what they were talking about. The Supreme Court, though, listened to all those arguments, but it had something else on its mind entirely. And it shocked everybody, but they didn't really pay attention to those arguments that Marbury and Madison were making. Instead, they held that the law, which gave President Adams the authority to appoint Marbury in the first place, was unconstitutional, and that the law that gave Adams that power violated the Constitution. So, because the law was invalid, Marbury's appointment was invalid. And so, poor Marbury, not only could he not get the court to force Madison to hand over the papers, the court said, well, Adams shouldn't have even drafted these papers in the first place because he shouldn't have had the constitutional power to do that, and the law that said that he could was wrong. It was unconstitutional. Well, that development really shocked everyone because the court declared that a law which Congress had passed, the president had signed, was illegal and void. And so here we have the third branch of government coming in and saying that the first two branches of government screwed up. And that was really a result that nobody was expecting. And that established that the Supreme Court had the power of judicial review. And that means that they have the power to examine laws to see whether or not they comply with the Constitution. And in fact, that is what the court does in large part today. And that's a huge check on the power of Congress and the president because it makes sure that their acts, whatever they do, whatever the laws they pass, whatever orders they issue, and so forth, that they have to agree with the highest law of the land, which is the Constitution. And so this case was very important for establishing that the Supreme Court gets to declare laws unconstitutional and throw them out. And so even if Congress has passed the law and the president has signed it, if the Supreme Court gets to review this law in a case that comes before it, they have absolute power to look through that law and figure out whether or not it complies with the Constitution. If they find that it doesn't, they can cancel that law. Just draw a big X through it and throw it out. And so it's no longer the law of the land. And so the Marbury case ensured that the judicial branch really would be co-equal with the legislative and executive branches. And that was something that was kind of up in the air there for a while. But Marbury versus Madison was very, very important for establishing that really the court could take on that role that the Founding Fathers envisioned of being the conscience of the government. They could be kind of the referees, making sure that the other two branches of government played by the rules. And so it really set up the system that we have today. Now we're going to turn to looking at the jurisdiction of the federal courts and also how the federal courts are structured, how they're set up. And so we'll not only look at how the different courts are kind of organized, but also the types of cases that they can hear and decide. The power of a court is determined by the limits of its jurisdiction. And jurisdiction is just the power to hear a case and enforce judgments that are reached in that case. So a pretty simple concept that becomes complicated sometimes, but very important. It's just jurisdiction defines what the power of a court actually is. And the court doesn't, if it doesn't have both jurisdiction over the type of case, which is what we call subject matter jurisdiction, as well as the parties to the case, what we call personal jurisdiction, then the court can't hear the case. And so we'll learn that there are only certain kinds of cases that federal courts can hear. So they only have subject matter jurisdiction over certain types of cases. You can't bring just any case you want in a federal court. It has to be a special kind of case. And also the parties to the case. We won't go into much detail about this, but for instance, let's say that you live in Neosho, you get mad at your neighbor who lives across the street in Neosho, and so you go sue him, but you sue him in a court in Alaska. And neither of you have ever been to Alaska before. Well, is that court in Alaska, can it hear the type of case that you're bringing against your neighbor? Probably. Does it have any jurisdiction over your neighbor, though? He doesn't live in Alaska, never been to Alaska, has no ties to Alaska? Well, no. And so the court doesn't have personal jurisdiction. So the court has to have the power to hear the type of case and has to have the power over the parties to that case. Now, if that's not true, a court can't hear a case. And so that's something a lot of people don't realize, is the court can't hear just any old case that it wants to. It has to be given the jurisdiction to hear any particular case that comes before it, or it won't be able to hear that case. Even the Supreme Court of the United States only has jurisdiction over certain kinds of cases. And the Constitution itself establishes that in some types of cases, the Supreme Court has original jurisdiction. And that means that the case can actually begin in the Supreme Court. The first day that you bring your lawsuit, it's in the Supreme Court of the United States. And I can't tell you how unusual that is, but it's extremely rare. But for instance, the Constitution says that a case involving an ambassador from a foreign country, if a case like that comes up, it goes straight to the Supreme Court, and it skips all the other steps and ends up right at the top from the very beginning. Also, a lawsuit between two different states. For example, if Missouri sued Kansas over something, that would end up before the Supreme Court. On day one, it wouldn't go through any other preliminary steps. It would just start out in the Supreme Court. You might ask yourself, well, why in the world would one state sue another? And it actually happens more often than you might think. And it happens a lot dealing with Missouri, actually, because of the Missouri River. And people will argue, or states will argue, about how much water the different states can take out of the Missouri River for irrigation or filling up a lake or whatever. And so, like Nebraska and South Dakota and Montana, I think, whatever other states are along the Missouri River, they'll end up in litigation sometimes arguing about, well, South Dakota took out too much water this year. They should have let some more of it flow downstream because we can't, get our barges to float here in Missouri and that kind of thing. So it does happen. It's just fairly rare. In terms of the proportion of cases, it's a minute percentage would actually begin in the Supreme Court, but it does have original jurisdiction over some kinds of cases. Again, those cases are extremely rare. Most cases have to start somewhere else before they get to the Supreme Court. Most of the work of the Supreme Court is actually done reviewing cases that were already decided in lower federal courts to determine whether or not the case was decided correctly. And so they will review those cases that were in another court first. And when they do that, that's what we call appellate jurisdiction. And that's the power to review a case that began in some other court. Back in 1789, Congress passed the Judiciary Act and created lower courts. They were given that power by the Constitution, so they created federal district courts and courts of appeal that handle cases below the Supreme Court. But they gave the Supreme Court appellate jurisdiction over cases coming out of those courts. And so the Supreme Court has the power to review cases that began in one of these other courts. In some cases, the Supreme Court can even review a decision by a state Supreme Court, such as the Supreme Court of Missouri. We will look at that court more when we look at Missouri and its constitution and government later on in the course. But if the Supreme Court of Missouri happens to issue a decision that somehow deals with federal law or the U.S. Constitution, the U.S. Supreme Court can step in and do something about that. Normally, the Supreme Court of Missouri is the final word on Missouri law. So if they make a decision about interpreting Missouri law, the Supreme Court of Missouri has the final say on that. But if the case that they're dealing with somehow touches upon federal law or the U.S. Constitution, the U.S. Supreme Court can step in and hear the case on appeal. So they have appellate jurisdiction over a lot of other courts, and that's normally how they spend their time, is dealing with cases coming out of other courts using their appellate jurisdiction. The system of federal courts that we have is really in three layers. And this is how it looks. You might have guessed I made this graphic myself. I'm very proud of it. It's very artistic. Um, at the bottom of this system, we have the district courts. Then above them, we have courts of appeal, which hear cases on appeal coming out of the district courts. Finally, at the top, we have the Supreme Court, which normally only hears cases that the courts of appeal have already had their say on. And so we'll look more at how all that fits together in a little bit. The district courts there at the very bottom are what we call trial courts, because that's where the trials happen. And most of the time when we see legal dramas on TV, or even some kind of reality thing or news coverage or whatever of a trial going on, where we have the plaintiff and the defendant, or the prosecutor and the defendant, putting witnesses on the witness stand, and the judge there, and the jury's in the box, and all that kind of stuff. That's a trial, and we have the district courts that handle those trials, so we call them trial courts. And that's where, if we're talking about a criminal case, where guilt or innocence is determined, or if it's a civil case, that's where liability is determined, who owes who money. The court will hear evidence and arguments on both sides and render a verdict and a judgment. And so that's what's going on in the district courts. The district courts are the trial courts within the federal court system, and 97%, probably, that's not an exact figure, just kind of an idea, of cases begin and end right there and never go on. So most cases are never appealed. Appeals are expensive, they're long, and they're drawn out, and so most cases begin and end right there in the district court. The other two layers mainly just hear appeals from cases that the district courts have already dealt with, and so they'll be using their appellate jurisdiction to review those cases that began in the district courts. The way that district courts are organized, there is at least one in every single state in the United States. Most states have more than one, and depending upon the state's population, and really more than population, it's the caseload that determines that, how many cases that are filed there, how many judges we need, how many courtrooms and courthouses, and that sort of thing. But of course that goes up the more people you have living there. And so every state has at least one, and most states have more than one. In Missouri, we actually have two federal district courts. We have the Western District of Missouri, located in Kansas City, and the Eastern District of Missouri, which is headquartered in St. Louis. And on this little map that I stole from the court's website, all those little gray counties on the western half of the state, those belong to the Western District of Missouri. So if you have a federal case that arises in one of those gray counties, which includes all of Crowder's service area there in southwest Missouri, you would be filing that in the Western District Court in Kansas City. If those little counties with numbers and white fill there, they are belong to the Eastern District of Missouri, and if you have a federal case in one of those counties, you would file it in the Eastern District Court in St. Louis. Actually, the Western District Court also has offices in other places, and has a kind of a branch office in Springfield, and hear some cases there. They even hear cases in Joplin occasionally. So they do get out away from Kansas City once in a while, but again, they're headquartered, and their main courthouse is in Kansas City. And so if you ever file a federal suit in the United States District Court for the Western District of Missouri, that would normally be filed in Kansas City. I already mentioned that courts can't hear just any old type of case that they want. They have to have jurisdiction over that case. And federal district courts cannot hear just any old case. They are given subject matter jurisdiction in particular types of cases. And those limits of their jurisdiction were set by Congress when it created the federal court system a long time ago. And Congress decided that state courts should handle most cases, and that federal courts should only be used in certain instances. And Congress gets to decide when the federal courts can hear a case and when they can't. They can set those boundaries of jurisdiction. Because federal courts can't hear just any kind of case that they want to, we say that they are courts of limited jurisdiction. That means they can only hear a few types of case that the law says that they can hear. And so Congress gets to set those limits, and just lets a few different types of cases get heard by the federal courts. On the other hand, state courts, and every state, including Missouri, has a system of state courts that kind of parallels the federal court system. Those state courts can hear almost any type of case, and so they are called courts of general jurisdiction because they can generally hear just about any sort of case. And so that's where most of the workload goes. In the court system today, most of the time a case is going to be heard in a state court unless it happens to be special, and we'll look at what special means here in just a little bit. So in order to bring your case in federal court, it must be of a type which Congress allows federal courts to hear. Looks like I have a typo in that last bullet point, so sorry about that. But it has to meet the requirements that Congress has set out. So if your case doesn't fit into the little mold that Congress has made, you have to go to a state court. So your case has to be kind of special to get into federal court because they do have that limited jurisdiction. So what kind of cases can make it into federal court? Well, there are two main types that end up in federal court. The first kind is if your case involves what is called a federal question, which means that it involves some law passed by Congress or the United States Constitution itself. And if your case somehow has to do with that, for instance, if you are suing your local police department because they violated your Fourth Amendment rights, well, that's a federal question because that's dealing with the U.S. Constitution. Or if you have a dispute with the EPA over some environmental regulation, that's a federal agency. And so that would be a federal case that could end up in a federal district court. So if you're dealing with some sort of aspect of federal law or the U.S. Constitution, then your case can be heard in federal court. Your case can be heard in federal court if it has what we call diversity jurisdiction. And this is kind of interesting because even if your case only involves questions of state law, it only deals with Missouri law, for instance, and has no federal question in it, a federal court can still hear it if there is what we call diversity jurisdiction. And diversity just means that you have a case between citizens of two different states, or diverse states is kind of the old way of saying that. And so if you have a lawsuit and the plaintiff is from Missouri and the defendant is from Kansas, then you could get that into federal court potentially. You might wonder, well, why in the world would they do that? Well, back when Congress created the federal court system, remember America was a very different place, and we looked at that way back in our earliest material talking about American history. But in those days, there was a lot of differences from one state to another, cultural differences and economic differences, and there was a lot of regionalism. And so people might have loyalty to their state before that they would the country as a whole, for instance. And so what they were afraid of was that, say that we had a Yankee from Massachusetts who ended up in the state court in South Carolina suing a resident of South Carolina. And the Congress wasn't confident that that South Carolina state court would be fair and impartial. They were afraid that they would kind of lean toward helping out their fellow citizen, their fellow South Carolinian, and not treat the Massachusetts Yankee fairly. And so Congress wanted to prevent a situation where citizens from a different state would end up in a court in a different state against a citizen of that state and then be treated unfairly. And so they wanted to give them some kind of alternative. And so Congress decided to let cases into federal court if the plaintiff and defendant were from different states to kind of prevent this from happening, the thinking being that a federal court would be fair and impartial because a federal court just owes its allegiance to the United States as a whole, not any particular state. And so we wouldn't have any bias against people who were out of state, basically. But Congress was kind of afraid that these diversity cases might flood the federal court system if they didn't place some kind of additional restriction on it. And so they created the amount in controversy requirement for diversity cases. So just having people from different states isn't enough. Your lawsuit also has to be worth a certain amount of money. You have to be seeking a certain amount of damages, basically, over a particular dollar figure. So that was designed to only let the most important cases where people from different states were involved into the federal court system and sort of keep the flood of all these smaller cases from overwhelming the federal courts. The amount in controversy requirement means that the amount of property at stake in a case has to be more than some minimum amount in order to get into federal court. So even if the plaintiff and the defendant are from different states, it still has to be a certain amount of money at stake, basically. And over the last 200 years, that amount has changed a lot. Right now, it's at $75,000. And so if your lawsuit involves people from different states and the amount in controversy is more than $75,000, then you can get into federal court based upon diversity jurisdiction. So again, to wrap that up, In order to use this diversity jurisdiction, get into a federal court, the plaintiff and defendant have to be from different states, and the amount at stake has to be more than 75 grand. So if those two things are true, you can file your suit in federal court instead of your state court. Now remember, if you have a federal question in your case, you can get into federal court without any kind of diversity or without any kind of amount in controversy. If there's a federal question, that doesn't matter. That's what the federal courts were originally there for anyway, was to work out these issues of federal law. And so you always have a right to file those in federal court without worrying about diversity or the amount in controversy. So two basic ways to get your case heard in federal court. And so that's how Congress has limited their jurisdiction. Once your case has been decided by the federal district court and you had a trial, and the judge entered a judgment or whatever, it may be appealed to the Federal Court of Appeals, and that court reviews decisions of the district courts. Most cases, though, never make it to an appeal. But our justice system gives unhappy parties a chance to have the district court's decisions looked at by that appellate court if they believe the district court judge made some kind of mistake in interpreting or applying the law. And certainly, we want to have a chance to correct mistakes, and nobody's perfect. So there are courts of appeals that sit there and review the cases that are being appealed from the district courts by an unhappy person who lost usually the case down below in the district court, who is griping about it and saying, look, my judge made a mistake, and then the Court of Appeals will take a look at that. The way that those courts of appeals are organized, we have 11 circuits, with each circuit reviewing the cases coming out of the district courts in this geographic territory. Now, I'll say one note about the word circuit. Normally we think of electronic gadgets when we're talking about circuits anymore, computers or something, but the word originally referred to the fact that judges would ride a horse and go from town to town to hear cases in these different towns. And so the judges would ride the circuit, and they would have kind of a circular path that they would go around riding their horse, and they'd set up shop in town for a couple days and hear the cases in that town, then go to the next. And so that's kind of a historic word that we use to describe courts, because a lot of times judges will hear cases in different places, and so they have a circuit. But anyway, so there's that. But so there are 11 circuits in the Court of Appeals, and we'll look at how those are set up on the next slide. So here we have a map showing the different circuits of the Court of Appeals. And if you look, we are in the 8th Circuit of the Court of Appeals in Missouri. And if you look carefully, you can see the boundary between the Western and Eastern districts of Missouri. And there's also Western District and Eastern District of Arkansas as well. And Arkansas, Missouri, Iowa, Nebraska, and those other orange states are handled by the 8th Circuit Court of Appeals, which is headquartered in St. Louis. Then in Kansas, Oklahoma, Colorado, and those yellow states over there, they're in the 10th Circuit, which is in Denver. And then the states on the left coast over there, California, Nevada, and Oregon, all of them, that's the 9th Circuit. And so if there's a case that's being appealed from any of these district courts within those states that are these different colors, you know which circuit they go to. So the 8th Circuit handles cases from the Western District of Missouri, the Eastern District of Missouri, and Western and Eastern Districts of Arkansas, Nebraska, South Dakota, North Dakota, Minnesota, Northern and Southern Districts of Iowa. So it just depends on what district your case originated in. Now you know where it would go if you took it up on appeal. And so these courts of appeal will just sit there waiting for cases to plop on their doorstep when someone was unhappy with how the case turned out in the federal district court. And so they will take a look at the case, see if the judge in the district court made an error of law, and then try to fix it one way or another. Well, if an unhappy party appeals his case to the Court of Appeals, but after the Court of Appeals gets done with it, he's still unhappy, he can ask the United States Supreme Court to review the case as well. However, the Supreme Court hears very few cases, and I don't know what the actual numbers are, but I'm guessing maybe 0.1% of all federal cases are even considered by the Supreme Court. Fewer than that actually get a hearing before the Supreme Court, and that's because the Supreme Court can pick and choose which cases it gets. And so that's how you see kind of our three-layer system working. Cases start in the federal district courts. If someone's unhappy, they can appeal to the Court of Appeals. And if someone is still unhappy, they can ask the Supreme Court to take a look at it. So that's just in general terms how the system is structured with our 3 layers of courts in the federal court system. So we're going to take a break from that for a second and kind of look at different kinds of cases and the kind of cases that we end up actually talking about in courts and how those cases will kind of wind their way through the court system. But this is the basic way that our court system is structured with these 3 different layers. Now we're going to talk about different types of cases before we go any further. I think it would just be helpful to get some basic legal terminology out of the way to kind of understand the different cases that courts hear. We just kind of need to understand that to get a better feel for the kind of work that they do and what the court system is really all about. There are 2 major types of cases that are heard by the courts. There are civil cases and criminal cases. A criminal case addresses a wrong against society. And so if you are arrested for murder, for instance, that's, certainly you killed somebody, that's a wrong against them. But really, what you're being punished for is because you're disrupting our orderly society. And you remember that the basic purpose of government is to provide that order, predictability, and certainty and all that stuff, and to protect its own citizens. That's part of that. And so to keep order in society, the government's in charge of punishing criminals. The people that do bad things, they need to be punished. They need to be maybe locked up so they can't cause any more mischief. And so that's what a criminal case is all about. There may be an individual crime victim in there, but when we prosecute a criminal case, when the prosecutor files charges and we try to throw that person in jail, we're not really addressing the wrong they committed against that individual. We're addressing the wrong they committed against society by being disruptive, and not allowing civilization to function and people to go about their lives in a peaceful manner. So that's what we're really doing there. So let's say, for example, Joe murders Sally. Well, Sally's a victim there. Obviously, she was wronged. But when we prosecute Joe, it's because the government has to keep order by punishing wrongdoers like Joe. It's the harm to society as a whole that the criminal law is really worried about. And it's not the individuals who are harmed. It's just society as a whole keeping that order. Otherwise, if we didn't have a criminal law system, criminal justice system, society would become lawless. People would just do what they wanted to do and, might would be right. So we don't want that to happen. That's what the criminal law is really concerned with. The civil case is different. That's a private dispute between 2 parties. And for instance, if you run a red light, you're careless, and you're texting or Facebooking or something, hit someone else's car, they can sue you. That will be a civil suit. You may get a ticket. That would be the criminal side of things. But, you wrong that person, you cost them money, you may send them to the hospital, and they got a hospital bill, they have to fix their car. So they need money to do those, take care of those problems. And so they're, suing you to get their money. That's a private dispute between 2 individuals, and that's what civil cases are all about. Well, keep in mind that a single incident may give rise to both a criminal case and a civil case. And so sometimes the same set of facts, we can have both going on. So as a for instance here, let's say that Jimbo is driving drunk and hit Shirley's car, injuring Shirley. Jimbo may be arrested for a crime, which would be driving while intoxicated, and may face jail time. And that's because of the disorder that he caused in society, and the government needs to fix that. However, Shirley may also sue Jimbo in a civil case, seeking compensation for her injuries. And so Jimbo committed a crime, certainly, but also it can give rise to a civil case in the same incident here. So a criminal case, that's what we see on Law and Order or, one of those other TV shows or, those true crime things that are so popular. A civil case, that's what we see on Judge Judy on a small scale. They get a lot bigger and more important than that, but, it's just individual people bickering about money usually. And I don't mean to diminish that, and sometimes some of those are really important cases, but anyway, so you can kind of see the difference here. A criminal case punishes the wrong against society, seeks to redress that. A civil case seeks to make things right when we have a dispute between individuals about some particular thing. Some more terminology here. If you've seen Judge Judy, you probably know this already, but in a civil suit, the person who brings a civil suit is called the plaintiff, and that's the person who is complaining, somebody wronged me, I need the court's help to make this right. And so that person is the plaintiff. The person being sued in a civil case, or the person being prosecuted in a criminal case, either one, is called the defendant. And so the defendant is the one defending himself. So that's kind of easy to remember. He's not the one that started this legal proceeding. He's the one trying to defend himself. There are two major classifications of criminal charges. The first, the most serious, is a felony. And that's a serious crime for which the possible punishment is more than 1 year in jail. So I say possible punishment because that's really what defines it, not what someone's actually sentenced to. So let's say that Billy Bob, gets in a bar fight and commits assault and battery, which is a crime, okay? And the jail time for assault and battery can be up to 2 years in jail. But Billy Bob, that's his first offense, so he's only sentenced to 6 months in jail. Well, he's still been convicted of a felony because the possible sentence could have been 2 years. He only got 6 months, but it could have been 2 years. And so that's how we measure how serious a crime is, by the possible sentence that you can get. And so if you commit some kind of crime and the possible punishment is longer than a year, that's a felony. And that's bad news because felonies are not something you want to mess around with. Less than a felony, we have what we call a misdemeanor. And so that's a crime, simply put. The maximum punishment possible is less than a year in jail. So pretty simple. If it's a year or more, it's a felony. If it's less than a year, it's a misdemeanor. So, if you get caught jaywalking and, get a ticket for it or something, that's less than a felony, that's a misdemeanor. We also even have things less than that called infractions that we deal with sometimes, where you just get a ticket and a small fine. But these are the two major categories of crimes that we would deal with: felonies and misdemeanors. And as I said, if you're thinking of committing a crime, stay away from felonies because they are a bad deal. You will lose some of the civil rights and liberties that we discussed earlier. As a felon, you don't have the right to own a firearm anymore. Your Second Amendment rights go away. You also lose the right to vote. And so also you may have a hard time getting a job because you're a convicted felon. And so there's certain things that you can't do anymore. So bad deal. Stay away from felonies. Think before you do something too stupid because that's not worth it. Let's take a look at kind of the way that a case winds through the court system, just to see kind of how our criminal justice system works and look at the different steps. And that, I think, will help us kind of understand just kind of the typical lifetime of a case, what the courts do on a daily basis. When we have a either civil or criminal case, just kind of how it winds its way through. That'll help us understand what the courts actually do. What are they there for? Either a civil or a criminal case begins with somebody filing paperwork, which is often, but not always, called a complaint with the trial court. And that will just say that, if it's a criminal case, it'll accuse somebody of committing a crime. Say, we caught Joe, running out of the 7-Eleven, carrying a big pile of cash and a gun, and the clerk said it was him that just robbed the store and blah, blah, blah. So we're charging him with armed robbery, so that's what will be in the complaint. And if it's a civil case, it'll say Jimbo was driving while intoxicated, ran the red light, caused a wreck, and injured me, and I hurt my neck. And so, again, that'll be called a complaint in many states. And so that's how the case begins. Somebody files that paperwork with the trial court. In the federal system, this is done at the federal district court. And in a state system, it would be done at the state's trial court, whatever they happen to call it. In Missouri, that's a circuit court. And we'll look more about that when we cover the Missouri Constitution toward the end of the course. But that's how it begins, just following this initial document with the trial court clerk. In a criminal case, it'll be the U.S. attorney who does this for a federal criminal case. And the U.S. attorney is the prosecutor for the federal government. And there's one of those in each of these districts that the district courts serve. And they'll have a number of assistant U.S. attorneys that'll actually do most of the work. But there's somebody in charge of that called a U.S. attorney. And just like a county prosecutor does that on the state court system, there's a U.S. attorney to do that in the federal system as well. If it's a civil case that we're talking about, it's just a private dispute between two different parties, usually about money, then the plaintiff will file suit and have copies served on the defendant. Usually the sheriff's deputy will go do that, but sometimes others as well. And once the defendant is properly served, then the case gets underway. And so that's just so the defendant will know that he's being sued. Somebody has to go deliver that document to him, so he'll get a chance to see who's suing him and what they're claiming in their lawsuit. Once our case is started, the district court judge will oversee the conduct of the case, but the judge is really just a referee. And it's not the judge's job to uncover the evidence. The parties themselves must do that. And so it's not the judge's job to, dig up the truth and figure out what the evidence ought to be, and you go asking questions and interviewing witnesses. The judge doesn't do any of that. The parties do that for themselves. And that's because our system is what we call adversarial. And what that means is our court system relies upon both parties, plaintiff and defendant, or prosecutor and defendant, and whatever we're talking about, to do a competent job in presenting the evidence in a way that their cases are presented in the best possible light. And so we rely upon the plaintiff's lawyer, usually, to represent the plaintiff's case in the best possible light. And then the defendant's attorney will get up and present the defendant's case in the best possible light. And the judge is just basically there as the referee to kind of oversee that both parties are following the rules and that everything is being done in an orderly manner. And so once both sides have presented their evidence, then all the court has to do is decide which side has the best evidence. And that's how we will decide the case. Now, I will note that this is not the way it works in some countries. As an example here, Spain, they use what is called an inquisitorial system. And there, the judge really serves as the chief investigator. And so the judge isn't just the referee, the judge is the one out interviewing witnesses and trying to dig up evidence and discover the truth. And that's not how American judges do it. They're waiting to see both sides present their best possible arguments, and then the judge just decide which one has the best argument, and that's how we discover what the truth is. So very different approaches, but in our system, it's an adversarial approach. And so because our system is adversarial, it depends upon both sides to be able to articulate their arguments really well. Because if the plaintiff's attorney does a really good job and the defendant's attorney does a really crappy job, we don't know that justice was served then, because we depend upon both of those sides to present their case in the best possible way. That's how we discover what the truth is. If we have both sides being ably represented, presenting really good arguments, then the judge is able to sit back and declare a winner fairly well, or a jury if we're using a jury. And so that's why our Bill of Rights guarantees that a criminal defendant has to be provided with a lawyer, even if he can't afford it. And I've heard people kind of gripe about that. Why do we have to pay tax money to hire a lawyer for some scumbag criminal, who, why are we the one footing the bill for that? Well, the reason that we're doing that is because our system breaks down if both sides aren't ably represented by attorneys. And so we're not going to be able to discover the truth of the case. If we have an illiterate criminal on one side who may not have graduated from high school, much less law school, if he's pitted against some prosecutor who did go to law school and is a pretty smart and articulate guy who's used to being in court, that's an unfair battle. And so that's not going to be a fair way to discover the truth, because one side will be able to present the facts really well, the other side won't. And so we really haven't arrived at the truth in a situation like that. In order to do justice, our system depends upon both sides to be represented really well by counsel. And so that's why our Bill of Rights, the Supreme Court has told us, we have to provide a criminal defendant with a lawyer, and we have to tell him about that even, so he knows he has that right. Even if he can't afford it, we have to provide him with counsel. So that's why, just because that's the way our justice system is designed, it doesn't work very well if we don't have both sides presenting really good arguments. And so it would be unfair to these criminal defendants to expect them to put on their own case if they don't really understand the law or what's going on in the court system. So we have to provide them with a lawyer. So that's just the way our system works. When we're trying to understand the judge's role in our legal system, a good analogy is like a referee in a football game. So, the judge doesn't get out there, and discover the evidence, and a referee in a football game, doesn't go out there and try to score points or anything. What they really do is they'll throw flags if they see someone breaking the rules, and penalize them appropriately, and at the end they'll declare a winner. And that's kind of what judges do in the legal system too. They will make sure everyone follows the rules, and they will issue a judgment at the end, decide who was right and who wasn't right. And it's up to the teams on the field in a football game to actually play the game and score the points. And similarly, in our legal system, it's up to the parties and their attorneys who are before the court to discover the evidence, to present that evidence, to make arguments and all that kind of stuff. And the judge is just like the referee sitting there trying to figure out who won the game, basically. So kind of an analogy there that'll help you understand really the role of the judge in the system. It's up to the parties to put on their case. The judge just decides based upon what the parties have put forward who comes out on top. So that's how our system is kind of set up. Well, judges do a couple of different things, but they mainly make rulings of law. And what that means is they will decide how the law applies to the particular case that is before the court. Let's take a look at an example to kind of illustrate this. Sally is suing Judy for running a stop sign and plowing into her car. Sally wants to put on evidence that 20 years ago, Judy spent her spare time strangling baby ducks for fun. And of course, that would prejudice the jury. They would hate Judy after hearing this evidence. So Sally wants to put that before the court. So the judge would apply the rules of evidence, which are legal principles, that's the law, to this set of facts. And the set of facts being, here's the kind of case we have, here's the evidence that one of the parties wants to put on, can we do that? And so they'll take the rules of evidence, apply it to the facts of this case, and the judge will rule that this information has nothing to do with whether Judy ran the stop sign, so it is irrelevant, should not be admitted into evidence under the law. So that's an example of a ruling of law. The judge will see what's going on in the case, go look and find out what the law says, and then apply that law to the facts of this case. And so make a ruling here on what evidence can come in or not come in. And that's a ruling of law, just making a decision of what the law allows the parties to do in the particular case. The other thing that a trial court has to do, other than make rulings of law, is to make what we call findings of fact. And this means to decide what evidence to believe and ultimately which side should win the case. So, for example, let's say in our Sally versus Judy case here, Sally claims that Judy didn't stop at the stop sign. Judy says that she did stop at the stop sign. Well, what's probably going to happen is Sally gets on the stand and testifies and says her side of the story. Judy's going to sit on the stand and tell her side of the story. The stories won't match, and so someone's going to have to weigh the testimony, the other evidence of the case, and make a finding of fact. Try to figure out, okay, did she stop at the stop sign or didn't she? Somebody's going to have to figure out who's more credible, who's telling the truth. And that's a finding of fact. Did she run the stop sign or did she stop at the stop sign? And so somebody's got to do that. And that's what trial courts have to do. In some cases, the judge will also make the findings of fact along with the rulings of law. But if we have a jury, that's what the jury's for, is to make those findings of fact. And so if we have a jury case where the jury is the one that's going to decide who wins and loses, the judge makes the rulings of law, and then the jury makes the findings of fact. And so that's really what the jury's job is. The jury's job is not to figure out what the law is and how the law applies to the case. The judge will do that and tell the jury what the law is. Then the jury will go try to figure out what evidence to believe, figure out who's telling the truth. If they find for Sally, they'll try to figure out how much money Judy owes her. And those are all findings of fact that the jury gets to do. So the judge will always make the rulings of law. Sorry about the typo there as well. Should have proofread a little bit better. But juries are often used to make findings of fact. And again, not in every case doesn't have a jury, but many cases do. And so if we have a jury, they're there to make the findings of fact. A criminal defendant, of course, we mentioned earlier in an earlier unit, has a right to a trial by jury unless he waives that right and opts to let the judge make the findings of fact. And criminal defendant might want to do that in particular cases, but if not, if he doesn't waive it, then he has a right to that trial by jury. And some civil cases will have a jury trial as well. When we have an appeal to the next level, that happens when one side argues that the trial court made an error in a ruling of law. And that's almost always the case. We're not arguing on appeal about the jury believed the wrong witness. The Court of Appeals is never going to overturn a finding of fact like that normally, simply because they weren't there in the room. When Sally was on the stand testifying and Judy was on the stand testifying, they weren't there to watch them testify, listen to them, get a feel for who was telling the truth and who was fibbing. So in a court of appeals who wasn't there in the room when all this testimony was going on, they're not going to second guess that normally. But what they can do is try to figure out, did the judge really understand the law properly, and did he apply it to this case properly? And so that's what will happen when we have an appeal, is someone will be arguing that the trial court made a wrong ruling of law. And so that's what will get us to the Court of Appeals if someone disagrees with a ruling that the trial judge made on a ruling of law. So once all the evidence is presented in the trial court, either the judge or the jury will take the case and decide what the facts are. So in this case, who is telling the truth about the stop sign and all that stuff, and then determine who should prevail. Who won, who was telling the truth, who should we decide for. So once they've done that, the judge will accept that verdict and then enter a judgment declaring who wins. And so the judgment will just say, verdict for the plaintiff or verdict for the defendant, and, they're awarded X amount of dollars, maybe if the plaintiff won. And if it's a criminal case, they will find guilty or not guilty. And later on, the judge will enter a sentence if it's a criminal case. So in a civil case, and there may be money awarded to one or more parties. And then, as I said, in the criminal case, a sentence will be entered if the defendant is found guilty, so he'll know how much fine he has to pay or how long he'll be spending in jail or that sort of thing. I want to take a couple of moments to talk about the burden of proof in these cases that come before a court, mainly because there's some common misconceptions out there about it, and also it's kind of interesting. So bear with me here. I'll talk about this for just a moment. To declare someone guilty in a criminal case, the jury must find that the evidence is so convincing that they are sure beyond a reasonable doubt that the defendant is guilty. And you've probably heard that terminology if you've ever watched any kind of police show or Law and Order type of show, that the prosecutor has to prove their case beyond a reasonable doubt. Well, what does that mean exactly? Well, it means that the jury is something like 90% sure. It does not mean absolutely certain. So in a criminal case, the prosecutor doesn't have to remove all doubt, just reasonable doubt. So for example, if the defendant is arguing that Martians actually committed the crime, or that he had a secret evil twin who committed the crime, well, you don't have to disprove all of those crazy theories. You just have to show that there is a very strong likelihood that the defendant is guilty beyond a reasonable doubt. And what reasonable is, is in the mind of the jury, in a particular case. But it has to be pretty darn sure that the defendant is guilty before we will find them guilty of a crime. So at least 90% sure, maybe more. And they don't have to remove all doubt. Don't have to deal with all those crazy theories in the evil twin scenario or something. But we have to be pretty sure that the defendant is guilty beyond a reasonable doubt. And so that is the standard in a criminal case. And so we're pretty familiar with that from TV and other things. However, the standard is very different than that in a civil case. And so when Sally is suing Judy, we have a different standard. It's no longer beyond a reasonable doubt. It's something else. Sally has to prove by a preponderance of the evidence that Judy is liable in order to win that case. Well, that just means she has to show that it's more likely than not that Judy was liable. So instead of talking about not being 90% sure, a jury in a civil case only has to be 51% sure. So, if they're trying to figure out who to believe, Sally versus Judy, they may not be really completely sure what happened, but if they think one's a little bit more believable than the other one, that's who they're going to go with. And that's all they have to have to render a verdict. So, very, very different. These two different standards in criminal cases and civil cases are why we have situations like O.J. Simpson. And if you're not familiar with that particular case, O.J. allegedly killed a couple of people, and he was not convicted of murder because the jury found that there was still reasonable doubt. The prosecution had not removed all reasonable doubt. And so he was found not guilty of murder, which was a crime. So that very high burden of proof in the criminal case was not met, is what the jury found. But the family of the dead people sued O.J. in a civil case for wrongful death, and that's a civil action. And so that had a much lower standard of proof, this preponderance of the evidence. And the jury in that case found that he was liable. And so we had two different juries, One said, we can't convict him of murder. The other said, well, we can find that he caused the deaths. And so that seems contradictory, but it's really not, because even if you think that both juries were right, they could still be consistent, because we're more than 51% sure that he did kill these people, but we're not more than 90% sure that he did. And so those verdicts are actually consistent, because a civil case uses a very different burden of proof than a criminal case. So I wanted to help you understand that, because the burden of proof is very different in these two different types of case. Once a trial court judge enters the judgment, the trial court's done with the case. And so after the judgment is entered and we've decided either one party won or the other party won, then the parties can either live with that judgment of the trial court, or if one of them is unhappy, they can appeal to the Court of Appeals and ask for them. When a case gets to the Court of Appeals, normally there will be a panel of 3 different judges who will be assigned to consider the appeal. So, of course, at the trial court level, we just have one judge. But here we have 3 different judges who will hear the case on appeal. So those judges will read the briefs, and they'll review the transcript of the case in the trial court, and then they will hear what we call oral arguments. An oral argument is just where the court sets a particular day and time, and the parties' attorneys will show up there and argue the case. And so they will, verbally tell the court why they believe their view of the case is correct, and the judges will be able to ask them questions and try to get them to defend their side of the case. And if you're an attorney, that can be fairly stressful, actually, getting up there in front of a bunch of 3 judges who are, asking you tough questions, but that's how that works. And so not only will they read these briefs, they will also be able to ask the attorneys questions during oral arguments. After all that is done, the judges will go huddle together in their chambers and try to figure out how the case ought to be decided. And that may actually take several months to decide a case, but they will discuss it and read the briefs and all the other stuff, take all that under consideration. And eventually they will issue a written opinion, which tells who they believe should win the argument and why. When the Court of Appeals decides a case, they really have 2 different choices. They can either affirm the case, which means that they let the judgment of the trial court stand. So in other words, they say that the trial court judge did not make a mistake after all, that his ruling, whatever we're arguing about, was correct. So they'll agree with the judge in the lower court. So if they affirm the case, that means they agree with that judge down below. But if they decide the judge was in fact wrong, they can reverse the case, which means they disagree with that judge and they can undo his or her decision. And no matter what they decide, they will normally remand the case, which means they will send it back to the trial court with instructions as to what to do next. And so if they affirm it, and they'll remand it and say, okay, trial court judge, you were correct and your judgment stands. Or if they reverse it, they'll say, no, trial court judge, you made a mistake. You need to figure this out, redo your decision because it was wrong, and then go from there. And so whatever they do, they'll send it back with instructions. So they can either affirm or reverse the case. Those are their two main choices. Well, even after the Court of Appeals has ruled, one of the parties may still be unhappy. And maybe they're unhappy for the first time, because if they won in the trial court and lost in the Court of Appeals, they will now be unhappy for the first time. Well, if they are still unhappy at that point in the federal court system, they can ask for further review from the United States Supreme Court itself. However, the bad news for them is the Supreme Court hears very, very few cases. And the fact is, the Supreme Court hears only the cases it wants to hear. And there's only 9 judges on that court. So they can't handle that many cases in the first place, and so they're pretty choosy. But if a party wants the Supreme Court to hear the case, what they do is they file a petition with the Supreme Court asking it to hear the case, and they'll explain why the case is important and the Supreme Court ought to handle it. And that petition has a special name in Latin. It's called a writ of certiorari, or we just call it cert for short in the legal community, because we get tired of speaking Latin, I guess. So that's just a petition asking the Supreme Court, please, please take this case, and so you can undo whatever the appeals court did that we're unhappy about. If the Supreme Court does take the case, they will issue that writ of certiorari to the Court of Appeals. When that just is a command, send us the case, we want to look at it. And so the Court of Appeals will say, yes, Supreme Court, and send that file to the Supreme Court so that they can take a look at it. But again, that happens pretty rarely. If a case does make it to the Supreme Court, the 9 justices who sit there will well, they will regularly meet to look at these petitions for writs of certiorari. And so they will decide which cases to take. So if you appeal to them, they get to sit around and figure out, do we want this one? Do we want that one? And figure out what cases they actually want to deal with. In order for the court to hear a case, 4 of the 9 justices have to agree that it's worth hearing. And that's kind of interesting. It doesn't take a majority. Just 4 of the 9 is enough. So if you can get a pretty strong minority of justices to think it's an interesting enough case to hear, then they will take the case and take a look at it. Usually, they will only choose cases where either one of 2 things is true. The first thing is the case is involving a very important issue dealing with the United States Constitution, or maybe some other aspect of federal law, but it's something that's really, really important that we really need to get settled. Or it could be a situation where different circuits of the Court of Appeals have decided the same issue differently. And then the Supreme Court wants to straighten that situation out, because we don't want different courts to be, in the same country to be deciding, 2 different things, or the same thing 2 different ways. We want some kind of stability and certainty in the law. And so if the 8th Circuit Court of Appeals says one thing and the 9th Circuit Court of Appeals says something else, the Supreme Court can weigh in and kind of straighten that out. And so those are usually only the 2 reasons the court will hear a case. It has to be something really, really important, some constitutional issue usually, or again, there's some kind of disagreement in the lower courts. If the Supreme Court does hear the case, the procedure is very much like what happens in the Court of Appeals. But in the Supreme Court, all 9 justices will hear every case. That is, unless one recuses himself, and that just means steps aside and refuses to hear the case, usually because of some kind of conflict of interest. And as a for instance, let's say that one of the Supreme Court justices, his daughter is a vice president at Walmart, and the case that's before the court involves Walmart. Well, it might be an ethical conflict of interest for him to hear that case. He might either not be unbiased, or he might at least look biased in that case. So he wouldn't be able to treat it fairly. And so to avoid that conflict, he might step aside. Well, after the case has been heard, and again, we'll have the written briefs and the oral arguments, the justices will meet behind closed doors to discuss the case and figure out what they think about the case and whether they ought to affirm it, reverse it, and why, and all that stuff. So they will meet and discuss and try to figure out what they're going to do about the case. Remember that there are 9 justices on the Supreme Court, and to reverse the case, to undo whatever the last court to hear it did, we need a simple majority of the justices, which would normally be 5 out of the 9, to reverse the case. And so if we get less than that, the case will stand. If there's an even number of justices deciding a case and there's an even split of votes, then that case is going to be affirmed because you need a simple majority to reverse it. So if you have a tie, the judgment will stand. We will affirm it. And so it takes a majority to reverse the case. And if we don't get that majority, it will stand like it is when it got to the court in the first place. Once the outcome of the case is determined, the justices will write opinions. And just like the Court of Appeals, they will explain what decision they reached and why they reached it, so everyone can kind of understand where they are coming from on that. There are different kinds of opinions that will be written. There will at least be a majority opinion in every single case. And that will be written by one justice on the winning side of the argument here. So if they all take a vote and 5 of the 9 justices agree, that's the majority, and that's going to be the law. So going forward, the opinion in that case, that's the law of the land. They will have decided this issue. So the majority opinion will determine whether the case is affirmed or reversed and explain why. Sometimes we have situations where we have other justices who agree with the outcome of the case of who won, but they will disagree as to the why. And so they have the choice of writing what we call a concurring opinion. So they agree with the result, but they want to, talk about, well, they came to the right decision, but, they didn't talk about this and they should have, and, this is why we should have reached this decision. And so they agree with the outcome, but they may disagree with the reason why we got to that outcome. And so they will have a concurring opinion. Then the losing side, there will be a justice, usually who disagrees with the outcome of the case, can write a dissenting opinion. And that'll just explain why he or she thinks the majority opinion is wrong. And say, the court screwed up here, and it should have found the other direction, and this is why. And kind of explain that reasoning. So we may have, from a single case, several different opinions. The majority opinion is the important one, or the most important one, because that's the one that will actually decide this case and also give us what we call precedent to decide future cases. And we'll look at that concept here shortly. It certainly takes a lot of time and effort to write all of these opinions. So why do we do that? Well, because our legal system operates on a theory called stare decisis, which is more Latin for you. And it just means let the decision stand. And this is the idea that we follow legal precedent. Or if a case has been decided before, and that will influence future cases and how we decide them. Once an issue has been decided, the courts don't want to waste their time deciding the same issue over again. We don't like reinventing the wheel. For example, if a court has decided once that buying a client's lunch is deductible under the federal tax law, they don't want to start over from scratch and redecide the same issue if it crops up in another case. And so, if somebody in New Jersey has, litigated this and figured out, got a court to rule that buying the client's lunch is deductible, why should we have to decide that same issue all over again in another state, if it comes up? Federal law covers the whole country, so why can't we just stick with that earlier decision and go with it in other places? And so that's the kind of the idea of precedent. Once we've decided an issue, we don't want to have to re-decide it all over again. And so that would just be kind of a waste of resources, and we might end up with decisions that disagree with each other too. And so to avoid that, we'll kind of follow these prior decisions. So these courts will look to the earlier precedent, and that just means a binding prior decision by a court, and will not waste time re-arguing that prior decision over again. So normally, if the U.S. Supreme Court, for example, has decided an issue, if that same issue comes up again, they're not going to change their mind. They will just look and say, oh, we already figured this out once before. And they'll go back to their precedent, read that opinion they wrote on that earlier case and say, look, see, we already figured this out once. Why do it again? And they will usually stick with that legal precedent. To kind of illustrate how stare decisis works in practice, I'm going to give you an admittedly stupid example. And I do things like that from time to time. So in our stupid example, we will be deciding the issue, is a tomato a fruit or a vegetable? And I've actually heard this debated by some fairly smart people before, so apparently it is a bone of contention. But anyway, let's say that we have a court case that hinges upon the decision legally is a tomato a fruit or a vegetable. Well, let's say that this issue is before the court, and the judge who is deciding the case, being the conscientious judge that he is, does some legal research and finds a case from earlier, let's say 30 years ago, and that decided that, in fact, tomatoes are a fruit. Well, at that point, that judge probably isn't going to spend a whole lot of time on the issue anymore. He'll just follow that prior precedent in the current case. And so, why wouldn't he? It'd be foolish for the courts to decide that tomatoes are fruit one day and then the next day reverse themselves and declare that tomatoes are vegetables. We want consistency in the law. We don't want the law to be changing on a daily basis, and we don't know what the law is. That's kind of unhandy. So rather than contradict ourselves constantly, we will just kind of follow that precedent. And so in this way, stare decisis prevents us both from reinventing the wheel on issues that have already been decided in the past and also contradicting ourselves, deciding in the same kind of case two different ways at two different times. And so that's how stare decisis can work. Stare decisis also helps us decide issues that are similar to issues in prior cases, but not exactly the same. To illustrate that, I give you yet another stupid example of precedent. In this example, we will be deciding, are peaches a fruit or a vegetable? Why would you think they're a vegetable? I have no idea. But let's say that we have this legal argument underway, and the parties arguing the case and just do some legal research and discover a prior case on whether tomatoes are a fruit or a vegetable. Well, admittedly, tomatoes and peaches are a little bit different, but the cases kind of look the same. The judge in the peach case might look at the reasoning in that tomato case for guidance on how to decide the peach case. And so he looks at that prior case that decided tomatoes were a fruit and sees that the judge in that case made a decision that tomatoes must be a fruit because they are round, juicy, and sweet tasting. Okay, so the judge takes that reasoning and then realizes that peaches, guess what? They're also round, juicy, and sweet tasting. And so the judge can rule that peaches are also a fruit based on the reasoning of the prior tomato precedent. So that prior case wasn't exactly the same. The facts were a little bit different, but the reasoning applied to this case too. It was similar enough we can kind of build on what the court in that earlier case did and say, okay, well, if tomatoes are a fruit, then we can kind of build on that and say, for the same reasons, peaches are a fruit as well. And so it's not exactly the same, but we can take that prior case and kind of build on that. And, the next time around, we might, have a different case about kumquats or something. We can see, oh, we have a tomato case and a peach case. And so we can build on that even further. So in this way, the courts will build up a body of decisions that will guide them in deciding future cases. And they can always look to the reasoning of prior precedent in order to help them decide current cases. And as a lawyer, if you're doing legal research, a good part of your time is spent looking at old cases, trying to figure out what courts have decided in the past. And if you are representing a client on a case, you'll be looking for a prior case where a court decided an issue that is in your case that was favorable, would be favorable to your client. And so you're trying to find old cases that look a little like your case and come out the way that you want it to. And so that's what legal research is really all about. And so that's how we build our body of decisions. That's the common law, if you've ever heard that term, as we build up this body of decisions over time by courts deciding these cases. And then that will guide us in future cases because we can look at the reasoning that courts used before. And so that's why those opinions are so critically important. If we don't understand what the court decided and why it decided the way that it did, we can't build upon their reasoning in future cases. And so that's why we write all of those lengthy opinions. I gave you two stupid examples in a row, so I feel like I owe you a semi-serious example. And we'll look at the civil rights movement. We talked about that in the Civil Liberty Civil Rights unit, and how those decisions of the Supreme Court really helped, especially African Americans in the civil rights movement, gain their rights and throw out segregation of the races. Well, First, you may remember we had a case, Brown versus Board of Education, declaring that segregation in public schools was wrong, that it was unconstitutional. Okay, well, that's public schools. Well, if we have that case on the books, it's pretty easy to take that reasoning in that case and apply it to public universities. It's just a different level of education, but it's the same kind of thing. It's taxpayer-funded education that's open to the public, so why would that be any different from a public K through 12 school? Let's apply it to a university too. Well, then we could take that case and kind of extend its reasoning to public buildings. Once upon a time, different races had to use different bathrooms and water fountains and things like that in public buildings. Well, if segregation is wrong in public schools and public universities, why not public courthouses, for instance? That sort of thing. And so the arguments of these prior cases could be expounded upon and extended to cover these new situations. We can build, just like, building blocks. We can, put one on top of another and kind of build, to new conclusions to meet these new situations. But none of this would be possible if the courts didn't issue those written opinions telling us what their reasoning was. If we didn't know why they came to their conclusion, we wouldn't understand how to build upon it and what it could do for us. So our system of stare decisis and precedent depends on judges writing down their reasoning so that can help us decide these future cases. That's just how the system works. Now, before we leave the topic of precedent, let's point out that precedent is sometimes not followed. Sometimes a court will reverse its course and not follow an earlier precedent. Once in a while, a court may just take a step back and say that, we're really sorry, in the past we had a prior decision, but it was wrong, so it'll correct that decision by overturning that prior precedent. And so really that's why we have those dissenting opinions, because sometimes the reasoning in those will be adopted as the law after a number of years. And this doesn't happen very often, and courts are reluctant to do it, because if it happens too often, our system of stare decisis would break down, and we wouldn't know what the law is. We couldn't rely on those precedents. But you may remember, before we had Brown versus Board of Education, we had PLSC versus Ferguson back in the 1890s. It said separate but equal is okay. It's okay to segregate the races, and there's nothing wrong with that. Well, that was just a stupid decision, frankly. And so it took until 1954, but the Supreme Court said, we're really sorry, but all those years ago, we screwed up. And so that's what the Brown case was about. It overturned that precedent in PLSC versus Ferguson and said, no, segregation of the races is not wrong, is not right, it's not constitutional, and we can't allow that anymore. And so sometimes, once in a while, a precedent will be overturned, but a court will not do that very lightly. It'll have to be very convinced that a mistake was made at some point in the past. I'd like to take this moment to give you an important note that we've been talking mainly about courts in the federal system, the U.S. Supreme Court and all the courts underneath it. We'll talk about state courts later when we examine the Missouri Constitution and the court system it has created for us. And it's a very similar setup and kind of mirrors the federal system with a few differences. But we will take a look at that. But remember, there's two parallel systems of courts in every state, the state courts and the federal courts. So with that in mind, you just need to remember every state has a court system that kind of looks like the federal court system in miniature, just within that state. And there are trial courts, courts of appeals, and a Supreme Court, and it operates pretty much the same way. Just deals with different sorts of cases usually. And so really throughout the United States, there's really 51 court systems because each state has one, and then we have the federal courts. I guess there may be more than that if you count Guam and Puerto Rico or something, but each state has its own court system, and the federal system exists as well. So we have all these different court systems working together, and the state courts nationwide probably do, 90% of the work and hear most cases, because remember, they have general jurisdiction, can hear just about any kind of case they want to, whereas your case has to be really special to get into federal court because they have that limited jurisdiction. And so the state courts should not be overlooked because they are the kind of the workhorses of our judicial system. They do the lion's share of the work there, but we are looking at the U.S. Constitution right now in federal courts, and so that's why we've been concentrating on that now. But the state courts are very, very important as well. Let's kind of close here by talking about the role of the judiciary and what what it plays in American politics and within our governmental system. Deciding cases is a primary role of the Supreme Court and the lower courts, of course. We were talking about that for most of this unit. Well, there is a debate, though, over the extent to which courts should go further and make public policy rather than just decide the law. And certainly that has happened in the past in some very important cases that we will examine in a moment. And what this means is, should courts have a role in defining what our goals as a society are, shaping our approaches to the problems that we face? And that's what we talk about when we are discussing policy. What are our priorities as a society? How are we going to approach the problems that we're dealing with? How are we going to overcome those? And do the courts have a role in that at all? And if so, what is it? Well, the Founding Fathers probably never expected the Supreme Court to create policy. That was going to be left to the legislative and executive branches. We expect the elected politicians, the Congress people, the senators, the president, to be the ones that figure out what public policy goals ought to be. What are we going to tackle as a society? Are we going to try to put men on the moon? Are we going to try to give everyone health insurance? What are we going to do? And they probably didn't envision a role for the Supreme Court in those kinds of discussions. But over the years, the Supreme Court has kind of found a role like that. But many people believe that it should be just like the Founding Fathers expected, that the Supreme Court really had no business crafting public policy. But at times, the court has taken some very active roles in shaping our public policy. And we've seen some hints of that, and we'll examine it in a little more detail. Now, for example, the court played a crucial role in eliminating racial segregation. We talked about that with the Brown case. Remember that for most of American history, segregation was a way of life. It was just ingrained in American society in a fundamental way. Before July 4, 1776, there was slavery in this country. So segregation, was there, as soon as the country was founded. And segregation had been approved by the Supreme Court in Plessy versus Ferguson in the 1890s, where the court declared that segregation was legal as long as the races were treated equally. Well, in the 1950s, of course, the court reversed itself in the case called Brown versus Board of Education. And so the court did an about-face, overruled its own precedent, and said that segregation is illegal. Well, at that time, in the 50s, much of American society was really not prepared for the end of segregation. And so this court decision caused a great deal of havoc. And we talked about that in the civil rights part of our material earlier in the class. And so this court decision really kind of turned American society on its ear a little bit back then. Well, we can all agree that the result was positive. Racial segregation is evil. I think, probably we can all basically agree on that, I would imagine. But there was a real healthy debate on whether overturning such a policy like that, this is a really sweeping decision that it really fundamentally changed American society. And was it really the place of a bunch of unelected judges to do that? Or was that a more appropriate topic for our elected congressmen and the president to deal with? Because these judges, for very good reasons, never face the American people in an election. They never have to be reappointed and campaign for their jobs. Once they're on the court, they're on the court. So is it really appropriate for them in that role to be making these kinds of sweeping decisions and shaping the course of American history and society and imposing these changes on America? So there is a big debate about that. Is that an appropriate role for the court? And again, we can agree that the result was positive in this situation, but, would it have been better to leave that to Congress, or was that appropriate for the court to do? And there's a big debate about that. There's also a debate about the court's role in abortion cases. The court entered a really heated debate with its decision in Roe versus Wade in the 1970s, that declared, at least in some cases, that women have a constitutional right to an abortion. And we saw that reasoning was based on the right to privacy, which is never explicitly mentioned in the Constitution. But based upon that right, the court legalized abortion throughout the United States, at least in certain situations. Well, prior to Roe, the states could decide on their own whether and in what circumstances to allow abortion. So they could outlaw them, they could allow them. It was really up to the state to decide that, and they could do whatever they wanted to do, whatever they felt was right on that. But that Roe case took the decision away from the states and introduced a new constitutional right, and that really upset a lot of Americans because it's a very hot button issue. People get really emotional about that. And so again, there was a debate about whether the court overstepped its bounds in crafting public policy. Should that have been debated in Congress? Should the president have been able to weigh in on that, or is it appropriate for a bunch of judges who, again, never faced an election, never had to respond to the will of the people, making such a sweeping change to American public policy? Was that appropriate or not? So there's been a big debate about that. And the debate on that proper role for the courts continues to this day. And in political campaigns, sometimes you'll hear debates about whether we want activist judges who legislate from the bench. And that just means, do we want judges who create public policy? And mainly conservative folks are against that. And so they'll be the ones usually shaking their fist in the air and saying, we don't want these activist judges. That's not their job to do that. And so nominees to the Supreme Court are regularly questioned about their philosophy on this and what the court's role really ought to be, because it's become a lot more than just reading these boring briefs and issuing these written opinions and going home at the end of the day. The Supreme Court has done some really major cases that have had a huge impact on American society in a major way, and so there's a healthy debate about that. It really shows no signs of any time soon. I think that'll be with us for a really long time, trying to figure out whether the court ought to stay within its boundaries, stay in its lane, so to speak, and stay away from these policy decisions, or whether that's entirely appropriate. So that'll wrap up our little sojourn through the Article 3 of the Constitution and the judicial branch. I will see you next time.